case briefs, and so much more. LSData's got what you're looking for.
In the landmark case, Augustine v. Department of Veterans Affairs, the United States Court of Appeals for the Federal Circuit in 2005 analyzed whether state law should exert influence over federal proceedings. The central argument examined whether attorneys practicing in federal cases must possess a relevant state license, a nuance that potentially has significant implications on the accessibility of legal representatives. Jumpstarting the case was the plaintiff, Cassandra Augustine, a veteran who believed she had been unjustly excluded from a civil service position by the Department of Veterans Affairs. Alleging it had violated her veterans' preference rights, Augustine requested attorney's fees under the Veterans Employment Opportunities Act of 1998, VEOA. However, her request ran against a wall as her attorney was not certified to practice law in California. Following its examination, the Merit Systems Protection Board, MSPB, rejected her fee request, hinged on the argument that her attorney was not a member of the state bar during the time services were rendered. This led to the pivotal question, if under Section 3330C(b) of the VEOA, the definition of an attorney should be influenced by state law. The subsequent unanimous ruling by the U.S. Court of Appeals remanded the case, arguing that state rule cannot interfere with or impede the federal processes. Simply put, California could not enforce that lawyers practicing before the board held specific state licenses or govern awards of the attorney's fees for work undertaken before federal agencies. Underscoring the decision was the assertion that any attorney with a license for practice in any state or federal jurisdiction had the authority to represent clients before the board and be compensated accordingly. Barred from incorporating state laws, the fee-shifting provision of the VEOA only deemed presence of an attorney-client relationship and a claim demonstrating entitlement to award under relevant statutory benchmarks necessary. The ruling confirms the position that in the context of Equal Access to Justice Act, an attorney refers to anyone formally trained and lawfully licensed for practice. As such, representatives licensed as attorneys in any state or federal jurisdiction have the prerogative to capture fees, irrespective of the licensing stipulations where services were delivered. With monetary awards removed from the equation, the case was remanded to the board for additional consideration of the attorney's application for fees.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class